The committee will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. Without objection, the members of the full committee who are not members of the subcommittee may sit on the dais and participate in today's hearing as well. And I should make note, we did have a floor whip update at approximately somewhere between 10 and 10:15. We'll have our first series of votes today, but it will be a relatively short one. So we're going to try and get through opening statements and get through this first panel, and then we will reconvene 5 minutes after the final vote on the floor. So, with that, the chair now recognizes himself for such time that I might consume for the purposes of a brief opening statement. I'm trying to pare that down, but this committee regularly considers matters of great technical detail, matters that can have a great effect on the world economy or on individual lives. What we don't routinely do is consider shooting wars or Americans who spend years in captivity by Marxist rebels. Today we'll be discussing those difficult topics and some matters of extraordinary complexity involving ways to fairly compensate victims of such these heinous acts. And in early 2003, Keith Stanzel, Mark Gonsalves, Tom Howes, and Tom Janis were engaged in a counter-narcotics operation in Colombia under the auspices of the Department of Defense when their plane crash-landed. They were captured by members of the FARC, a violent guerrilla group that has funded itself by kidnapping and narcotics trafficking while in armed conflict in Colombia since the mid-1960s. The guerrillas executed Tom Janis at the crash site, and the 3 remaining men were held hostage and tortured for more than 5 years until they and a number of their hostages were rescued by the Colombian military. Today's hearing will focus on matters related to the execution of court's judgments against assets of the FARC for actions taken against these American hostages captured in Colombia. And I've got quite a bit more, but I'm going to, in the interest of time, I think I'm going to dispense with that. And with that, I don't know that we have anybody on the other side, not yet. So if that is okay, what we will do is recognize Mr. Posey for 3 minutes for an opening statement.
Thank you, Mr. Chairman. I'll be brief. I would like to thank Chairman Hensling for calling this hearing. Thank you for your support and the committee for the support to grant justice to the victims of narco-terrorism. The 3 surviving former FARC hostages, Mark Gonsalves, Keith Stansel, and my constituent Tom Howes are here today. We'll hear from them in a little while. Unfortunately, the family of Tom Janis, who was executed by FARC, cannot be here today. These men put themselves in harm's way to provide service to our nation and were hostages of the FARC for 5.5 years, longer than I've been in Congress. They've endured hardships beyond imagination and are American heroes who deserve our respect and our admiration. Congress gave these men the right to sue FARC captors in federal court. Congress also passed Section 201 of TRIA, which gave the victims of terrorism the ability to seize assets of terrorists and their agents. Unfortunately, TRIA does not currently allow these men to seize assets of FARC-related drug smugglers, money launderers, and gun runners because they're blocked under the Kingpin Act. The Treasury Department has chosen to block FARC assets only under the Kingpin Act, even though they would be blocked under other statutes that would allow them to seize assets. Furthermore, the Treasury Department believes that it's better to use blocked Kingpin assets to negotiate with narco-traffickers than to allow victims of these terrorists to have access to these funds and to settle their court-adjudicated claims. These men have repeatedly asked Treasury to reclassify FARC assets to allow them to seize them, but were either ignored or denied. There's no administrative solution, and legislative action is necessary. Our staff spent months reaching out to the administration to get their comments on the bill. They responded one time, and we made massive changes to the bill to address their concerns. It is the smallest change in the law necessary to achieve the objective. I'm therefore glad to have this opportunity to demonstrate how and why we introduced the BASTA Act to remedy this injustice, and I thank you, Mr. Chairman, and yield back.
Gentleman yields back. And with that, we're going to move right to our panel. I'd like to extend a welcome to our first panel of witnesses, Jennifer Fowler, Deputy Assistant Secretary for Terrorist Financing and Financial Crime, Department of Treasury, and Marshall Miller, Acting Principal Deputy Assistant Attorney General and Chief of Staff, Department of Justice. You'll each be recognized for 5 minutes and to give your oral presentation of your testimony. Without objection, your written statements will be made part of the record after your oral remarks. And, of course, in front of you on the table is the series of lights, green, then to yellow. It'll have 1 minute to sum up, and when it turns red, I will be quick with the gavel today. So once each of you has finished presenting, each member of the committee will have 5 minutes in which to ask any questions. So, Ms. Fowler, you are now recognized for 5 minutes.
Thank you, Chairman, Ranking Member, members of the subcommittee. I appreciate the opportunity to appear today before you to discuss the proposed bank account seizure of terrorist assets amendment and its potential effects on Treasury's implementation of the Foreign Narcotics Kingpin Designation Act, commonly known as the Kingpin Act. Before I begin, I want to extend my deepest sympathies and that of the Department of the Treasury to all victims of violence, from terrorism and all other crimes, and strongly condemn all violent acts by terrorist organizations, including the Revolutionary Armed Forces of Colombia, or the FARC. For nearly 15 years, the Treasury Department has robustly implemented the Kingpin Act to disrupt and dismantle narcotics trafficking organizations like the FARC and deprive them of the resources needed to carry out their violent activities that threaten U.S. and global security. The Kingpin Act prohibits transactions with foreign narcotics traffickers identified by the President and provides authority for Treasury's Office of Foreign Assets Control, or OFAC, to designate foreign individuals and entities that are acting on behalf of the designated kingpins. This authority allows OFAC to go after the financial and support networks of drug trafficking organizations, including the money launderers, front companies, and transportation and communications firms facilitating their activities, as well as the assets where they store their wealth. The Kingpin Act is one of the most powerful and effective tools we have to disrupt the financial underpinnings of narcotics trafficking organizations. These sanctions have been used with great success against traffickers in Mexico, such as Los Zetos and the Sinaloa cartel, in Colombia and throughout Central America, particularly in Honduras and Guatemala. The Kingpin Act has a global reach, and OFAC has targeted drug traffickers around the world, including in Afghanistan, Lebanon, and Nigeria. Since June 2000, more than 1,600 individuals and entities have been named pursuant to the Kingpin Act for their role in international narcotics trafficking. This authority has been enhanced by our robust cooperation with foreign governments and law enforcement, who have often initiated investigations in their own countries based on our designations. These foreign investigations, sparked by Kingpin Act designations, have resulted in numerous seizures and arrests abroad. The seizure by the Honduran government in September 2013 of $500 million in narcotics-linked assets was done in close coordination with OFAC on a Kingpin designation. It was the largest drug-related asset seizure in Honduran history. Financial sanctions have been called a civil death by narcotics traffickers themselves due to their subsequent inability to maintain banking and commercial relationships. These financial sanctions isolate them from the U.S. financial system and often the financial system in their own country. In addition, if the traffickers have assets in the United States, these assets are blocked or frozen, and access to the assets is controlled by the government. Traffickers must then petition OFAC and demonstrate a change in their behavior for the designation to be lifted and to regain access to those frozen assets. Using access to these frozen assets is an important point of leverage to effect behavioral change by narcotics traffickers. Since 2000, 200 Kingpin Act designees have come to us to petition for removal. After thorough investigations, OFAC agreed that 137 of them had demonstrated a credible change in behavior and therefore removed them from the SDN list. In some cases, designated individuals showed proof of credible change by agreeing to cooperate with U.S. or foreign law enforcement, by renouncing any rights to foreign assets derived by narcotics trafficking, or by severing their ties to front companies. The Terrorism Risk Insurance Act of 2002, commonly known as TRIA, allows for a person who has obtained a judgment against a terrorist party to attach any blocked assets of that terrorist party in aid of satisfying such judgment. Currently, the term blocked assets, as defined by TRIA, refers only to assets frozen by the United States pursuant to the Trading with the Enemy Act or the International Emergency Economic Powers Act. The Kingpin Act, on the other hand, was specifically created to address the separate threat to our country and our national interests posed by the activities of international narcotics traffickers. Amending TRIA's definition of blocked assets to include property frozen pursuant to the Kingpin Act could have potentially negative effects. We expect that, as applied, this amendment could result in the attachment and depletion of blocked assets of non-terrorist-related narcotics traffickers, including those operating in Mexico, Central America, and Colombia. This could limit Treasury's ability to use these blocked assets as leverage against dangerous groups such as the Sinaloa cartel, Los Zetos, Los Cacheros, and Colombian criminal gangs involved in the drug trade. In closing, I want to urge Congress to give careful consideration to the potential impact any amendment to TRIA may have on the targeting of drug trafficking organizations under the Kingpin Act. Thank you very much for the opportunity to be here today, and I welcome any questions.
And I assume you yield back the balance of your time. With that, we would like to now recognize Mr. Miller for 5 minutes.
Mr. Chairman, distinguished members of the subcommittee, thank you for inviting me to speak at this hearing. The Department of Justice is fully committed to using all of our prosecutorial tools to combat terrorist and narcotics trafficking organizations. The primary approach employed by the dedicated prosecutors at the Department of Justice is the prosecution of members and associates of such groups for their criminal acts. We also employ our forfeiture authorities to seize assets, and we pursue vigorously restitution for crime victims. The Department works with crime victims on a daily basis to ensure they receive justice for the harms they've suffered. Specifically, the seizure and forfeiture of assets that represent the proceeds of federal crimes or that were used to facilitate those crimes are covered by the Department of Justice's Asset Forfeiture Program. The program's primary mission is to use asset forfeiture to enhance public safety and security by ensuring that crime does not pay. To accomplish that mission, the Department forfeits the proceeds of crime or other substitute assets directly from the criminals themselves. Asset forfeiture thus takes the profit out of crime, disrupts criminal organizations, lessens their economic influence, and serves as a deterrent to future criminal activity. In addition, the laws governing asset forfeiture provide pretrial preservation tools to prevent criminal defendants from dissipating crime proceeds, ensuring that such proceeds remain available for forfeiture or restitution. The Criminal Division's Asset Forfeiture and Money Laundering Section, or AFMILS, spearheads the asset forfeiture program and, more generally, the Department's asset forfeiture and anti-money laundering enforcement efforts. Most importantly for today's hearing, AFMILS leads the Department's efforts to return forfeited criminal proceeds to those harmed by crime through the administration of victim claims. The Department works to ensure that victims of crime are fairly and equitably compensated. The authority to distribute forfeited funds has been entrusted to the Attorney General. This makes sense legally because once property or funds are forfeited, ownership of the property or funds in question transfers to the government. But it's also sensible, as it allows the government to finalize and execute forfeiture orders fairly without prejudicing the rights of any claimants. The process by which the Department distributes forfeited assets is known as remission. Under the applicable regulatory framework governing remission, the Department has provided compensation to thousands of victims for a wide variety of crimes, ranging from Ponzi schemes, mail and wire fraud, and healthcare fraud, to identity theft, intellectual property, and trademark violations. Since 2001, nearly $4 billion in forfeited assets have been disbursed to victims by the Department under the Attorney General's authority. Over $203 million has been returned to victims so far this year. The remission process is governed by federal regulations that define a victim as an innocent person who has suffered a pecuniary loss as a direct result of the crime underlying the forfeiture or a related offense. It's important to note that the remission regulations give no preferential treatment to any particular victims. All victims must submit and document their losses with supporting documents. When the forfeited funds are not sufficient to compensate multiple victims for the entirety of their losses, the funds are generally distributed on a pro rata basis, in accordance with each victim's verified pecuniary loss amount. An important purpose of these regulations is to avoid victims of crime being doubly harmed, first, by the underlying criminal conduct, and a second time, as resources are dissipated as victims are forced to compete over a limited pot of money. The Department remains steadfast in its commitment to ensuring that forfeiture plays a key role in helping victims recover from the crimes committed against them. If I might take a brief moment, I would like, on behalf of the Department of Justice, to express our strong feelings of sympathy, respect, and admiration for the FARC hostage-taking victims, particularly Mr. Howes, Mr. Stansel, and Mr. Gonzalez, who are here today, as well as the families of those who lost their lives during that crime. Their resolve, tenacity, and dedication to this country in the face of horrific treatment from their FARC captors are truly inspiring, and the Department of Justice will not rest in our efforts to bring their captors to justice. I'd like to again thank the subcommittee for holding this hearing and providing the Department with the opportunity to explain our forfeiture efforts, remission procedures, and commitment to compensating the victims of crime. I'm happy to answer any questions that you may have, and I yield back any time that I still have. Thank you.
The gentleman yields back. Thank you for doing that. At this time, the Chair yields himself up to 5 minutes. And with that, I'll start with you, Mr. Marshall. So as we were talking about, this is rather technical and those kinds of things. Help me understand the technical differences between blocked, frozen, seized, and forfeited assets, and really under what the circumstances are. I know you were touching on that, and I want to make sure that as you were talking about the pecuniary damages that have happened, how this is, I'm assuming part of this is that how do you quantify monetarily what the damage is? Is that where part of the hang-up is? But with that.
Thank you, Mr. Chairman. To begin with the first part of your question, there is a significant difference between blocked and frozen assets on the one hand and seized and forfeited assets on the other. And I can let my colleague from the Department of Treasury speak a little more about frozen and blocked assets, but essentially those are assets that remain under the ownership of the original party whose assets were blocked. They can't access those assets, they can't use those assets, but they remain in their ownership. Seized or frozen assets mean assets that the Department of Justice has taken action to actually assume ownership of. So when a criminal prosecution is filed and forfeiture allegations are included against particular assets, we, the Department of Justice, get a warrant to seize those assets and then begin the process of actually taking ownership of them. So when the assets are ultimately forfeited, ownership transfers to the government of the United States. Those are important tools that we use in criminal cases, the forfeiture authorities, to stop criminals from dissipating those assets during the pendency of a criminal prosecution, making sure that those assets are seized, and thus at the end of a criminal prosecution they can be provided to victims through restitution or forfeiture, or ultimately forfeited to the United States.
So in your testimony, though, you talked about focusing on victims who have suffered, quote, quantifiable pecuniary harm, as the regulations set forth. Quantifying non-pecuniary harm is a very difficult process. Is there no way of determining financially what the harm was here?
Well, one way that takes place, Mr. Chairman, is in the restitution process. So in an individual criminal case, there is at times courts can attempt to quantify harms to individuals that aren't the loss of particular funds. So in a non-fraud case, for example. When funds are forfeited, the regulations that govern the remission process do require proof of some sort of quantifiable pecuniary harm. To attempt to quantify a non-pecuniary harm is not called for within the regulations, and is, as the Chair recognized, a difficult process, one that could consume significant resources as the Department or some independent body attempts to figure out what dollar figure should attach to non-pecuniary harm, and then resolve the differences amongst potentially numerous victims with respect to that harm.
All right, and I've got a minute and a half, and we did just have votes called, and we're going to try and get through this. But see, Ms. Fowler, help me, we have a minute left. Help me understand, though, the decision-making process if this is blocked under the Kingpin Act as drug traffickers' assets rather than terrorist assets, even though FARC has been designated a terrorist organization.
Yes, the FARC is designated under both authorities. It's designated as a terrorist organization, but it's also designated by the President as a kingpin under the Kingpin Act. We have pursued designations of kingpin leadership and other elements of its financial and support network under the Kingpin Act. That's the authority that we use to go after drug trafficking activities globally, as I said in my statement. We have been focused on depriving the FARC of its money-making capabilities, and that revolves around the drug trade. So we have focused on our actions under the FARC, under the Kingpin Act. There's also a robust law enforcement cooperation that goes on within the auspices of the Kingpin Act. We rely on information from law enforcement, from our partners, domestically to carry out those designations. So that's how we've chosen to sort of dismantle their financial support network.
And my time has expired. With that, the chair recognizes Mr. Posey for 5 minutes.
Thank you, Mr. Chairman. Ms. Fowler, in your testimony, you said, and am I assuming that you oppose the legislation that we're looking at now?
We haven't taken a position on the legislation. I'm here to provide, be a resource to provide information
Treasury
about potential consequences, but we haven't taken a position yet.
So Treasury doesn't care one way or the other. Is that correct?
We're still assessing it.
Well, when are you going to finish assessing it? I mean, it's been months and months and months. These victims have been looking for years to do something. I mean, when are you going to come up with an assessment? When are you going to really care one way or the other? If you don't have an answer for that, that's okay. In your testimony, you said this bill, by allowing these people to be eligible for compensation for being murdered and tortured, you said it could limit the Treasury's ability to use blocked assets as leverage against dangerous groups, such as, and you listed them. These people have been harmed by dangerous groups. Could you explain to me how letting these guys recover from terrorists, from narcotics dealers and terrorists, is going to harm your ability to deal with other narcotics dealers and terrorists?
So the amendment as drafted, what we would expect its application to include would be assets of non-terrorist related drug trafficking groups, non-FARC related groups. So groups like Los Zetas and other groups in Central America that are involved in the direct distribution of drugs into the United States. That application would make assets that are not terrorist related available to terrorist victims. That's the potential consequence. And as I said in my statement.
Okay. So I mean, if I was just watching this on C-SPAN, I mean, I'd think Treasury is more interested in protecting the assets of drug runners and terrorists than they are for compensating the victims of those people. And I think that's why it was set up originally under TRIA. My time's running short here. Mr. Miller, you talk about all the variety of crimes that y'all have helped recover compensation for victims of Ponzi schemes, mail and wire fraud, healthcare fraud, identity theft, intellectual property, and trademark violations. Since 2001, nearly $4 billion in forfeit, and those are crimes that people should be compensated for. But I think above all of those are victims who have been physically tortured and murdered. And I think they should have some priority in this process. And the we say, or you said, that the Justice Department won't rest until bringing the perpetrators to justice, and and I know you never will. So I would think the best thing that you could do is endorse at this time trying to get the victims compensated. And I should ask you to begin with, do you oppose this bill?
Well, to begin, Congressman, I think this is a bill as currently drafted that really doesn't address Department of Justice equities directly. It's really more in the Department of Treasury's lane.
Do you oppose it or support it?
We defer to the Department of Treasury as it affects them.
And they don't care one way or the other at this point, and you don't care one way or the other at this point. Is that correct?
Well, I wouldn't put it that way, Congressman. The Department of Justice is, as I said, committed to bringing to justice the captors, and we have had some success.
Well, I know you never will, and I think you know in your heart you never will. And I'd like to stick to this bill, and you said you defer to the Treasury, and they say they really don't care, that they haven't had time to possibly analyze this since 2002, and don't know when they're going to be able to finish analyzing it. And we're basically kind of interested in solving problems up here. And nobody's come up with any other better idea to solve the problem. They've only come up with ways or objections or treading water to stop us from solving a problem. And that's narco-terrorist murdering and torturing people without any remedy for the victims.
Well, Congressman, as I think you know, we've charged over 15 defendants with these crimes. One of them is pled guilty and is due to be sentenced. At least it's scheduled for next week. It may get pushed off, as I understand it, but I'm not certain about that. But as of now, it's scheduled for next week. An additional defendant was sentenced to 60 years in prison. So I think we do continue to fight for justice in terms of actual prosecutions of these the individuals involved in this offense, and I don't think that we view it as something that can never happen. We fight every day to make sure that it does happen.
Why would you want to block us from allowing these people to recover court-awarded damages to narco-terrorists?
I don't think the Department's position is that we look to stop people from obtaining restitution where we can fight to make that happen. We pursue restitution orders for terrorism victims in cases across the country.
The gentleman's time has expired. In the interest of time, we've got about 4 minutes left, I think, of voting. I'm sorry, what is it? My eyes are getting bad. I'm trying to see a screen. 7 minutes left of voting, and with that, we'll recognize Mr. Mulvaney for 5 minutes.
Thanks, and I'll try and be un-Southern and talk fast for a little bit. Ms. Fowler, Mr. Miller, I'm going to do something unusual for a politician, admit to you in advance that I don't know that much about what we're dealing with. So I'm going to do something rare and actually ask questions with a desire to simply learn about the topic. So, Ms. Fowler, you mentioned during your testimony, I've got it in front of me, that one of the TRIA added trading with the enemy and IEPA to as this fund that victims could get to. And you say in your testimony that you're against against adding Kingpin to that because it would limit your ability to use them as leverage. I don't get that. Why was using trading with the enemy okay and IEPA okay, but Kingpin is not?
Oh, the reality is Kingpin was in place as law when TRIA was put into place as law. So
right.
I don't know why it wasn't brought in as part of that legislation. It is clearly not part of TRIA. The assets blocked pursuant to Kingpin Act are not available to victims under TRIA. I didn't say that in my testimony that we oppose the amendment that's being proposed. We are still assessing it. What I've tried to do is explain what the potential consequences are if this amendment goes through. And what we've seen is...
But y'all didn't oppose adding IEPA and trading with the enemy, right?
I really couldn't speak to what our position was at that point.
Well, actually, my notes say that you didn't. So I'm trying to figure out the distinction. What's the difference between these two things? Why is it okay to use IEPA and TWIA but not Kingpin? So
under Kingpin, there are a variety of non-terrorist-related narcotics trafficking groups that are targeted under Kingpin.
Right.
They are not involved in terrorist activity. What they are is motivated by profit. They're involved in this dangerous criminal activity that's bringing drugs into the United States. So they are not terrorist groups. The FARC, however, happens to be both a terrorist group and a drug trafficking organization. So they are blocked under both authorities. What some of the testimony submitted today suggests is that any group that's involved in cocaine trade anywhere should be considered part of the FARC. Under our authorities, there are very clear definitions about who is part of the FARC and who is not. We have groups like Los Zetos, other groups in Honduras and Guatemala that are... And
you mentioned that, and you say that the proposal could limit Treasury's ability to use these blocked assets as leverage.
So for the assets that we have blocked for terrorist groups, there are many points of leverage that we have under our authorities. One point of leverage is the frozen assets that could be blocked in the United States.
Right.
If you're a drug trafficker motivated by profit, you certainly want to regain access to the assets that are blocked. We've had examples over the years where drug traffickers or people who are facilitating their financial activities motivated by profit are named under Kingpin. They find themselves exposed publicly for what they're doing, involved in criminal activity, supporting drug traffickers. They can't do business in their host countries anymore. They can't do business in the United States. They have no access to their assets. So every point of leverage we have under our authority is a way to consider, to convince these drug traffickers to disassociate from those activities,
But,
to potentially, and in many cases, to
and
join
I don't want to cut
law
you off.
enforcement and help us in continuing investigations.
But-
And that's been one of the benefits of this.
Right, but I guess my point is that drug traffickers are bad people, terrorists are bad people. It looks as though Treasury was okay with giving up that leverage against terrorists in TRIA, but not on Kingpin. I'm trying to get my handle around the disparate impact, not only on, I guess, on the law, but on the victims. It's almost like if you're a victim of a terrorist attack, we've got systems set up to help you, but if you're a victim of a drug dealer, you're not. And that's what I'm trying to get my hands around as to why Treasury sort of makes the distinction between the two. Shouldn't we have consistency across those two things?
I don't think Treasury is making the distinction. TRIA makes the distinction. It doesn't include Kingpin.
Right, but my understanding, and again, I could be wrong, and maybe you weren't there. I certainly wasn't here when TRIA was passed in 2002, but all the history that I've been presented with seems to say that Treasury supported the addition of IEPA and TWIA to TRIA. If I'm wrong about that, then I'm wrong about that.
I'm sorry, I can't speak to what our position was on that 10 years ago.
All right. Help me, either of you. What have you done to actually help the victims that are here today? I've had their names, and I'm sorry, Mr. Howes, Stansel, and Gonzalez. What have we actually done to try and help these folks?
Well, at the Department of Justice, as I said a few moments ago, we've been working very hard to bring to justice those who perpetrated crimes against the individuals who are here today.
Sure, and that helps everybody in the room, right? I'm asking specifically, what have you done to help these folks?
Well, I think going after the people who harmed them and who committed crimes against them is an important part, at least from the Department of Justice's perspective, of how we go about helping victims. We think, our core mission is to prosecute the individuals who commit horrific crimes and to bring them to justice, and we stand committed to doing that in this case and in any other case. Through that process, we also pursue restitution, and where we can, we forfeit assets from the individuals who committed and the organizations that commit offenses. So that's what we do to try to look out for victims, and we work very hard on.
And again, Mr. Miller, I don't know that much about the individual case, but I'll ask the question: has restitution been made in this circumstance or not?
I believe that my understanding is that the individuals who have so far been prosecuted had insufficient funds to satisfy, for example, the $300 million judgment that's been entered. But we continue to work very hard to bring to justice those who were involved in the offenses.
Thank you, Mr. Chairman.
And with that, it was an inattentive committee chairman trying to figure out our votes here. We did go a bit past, but I think we can squeeze one more in. We've got Mr. Stutzman from Indiana recognized for 5 minutes.
Thank you, Mr. Chairman. This time I will yield to the gentleman from Florida.
I thank the gentleman for yielding. Just to follow up on Mr. Mulvaney's question, the individuals who you ultimately convict conveniently never have any assets by the time they're convicted, so they can make no restitution. Bernard Madoff, by the time he basically turned himself in, still had some assets that you were able to help get and get back to some of his victims. But I'm concerned that there seems to be no interest in compensating the victims of narco-terrorism. You've got the whole laundry list of white-collar crimes that you've helped compensate the victims for, and I just haven't heard any justification yet, and I was hoping I would hear it today, if there was, in fact, a fair and realistic justification for not wanting to see the victims of narco-terrorists, people who were in prison for 5.5 years, people who were tortured, people who didn't endure the torture and died, their families. I mean, I think some restitution is due there, and I see you two right now, maybe wrongly, but I see you and your agencies, for whatever reason, I don't know, standing in the way of seeing justice for the victims. And I wish you'd tell me why that's not true. I mean, I've heard you say, well, if we let the victims get the money, then we can't use their assets to maybe stop them from doing something else. Well, freezing their assets, I think, is probably less beneficial to leveraging against terrorists and narcotics operations less threatening to them than actually allowing a court-adjudicated access to it for victims that they have victimized. I mean, wouldn't you agree?
Congressman, we're not opposed to victims having access to assets that are properly available for attachment under TRIA. The issue here is that Kingpin Act assets are not covered by TRIA. And
Repeat
in the case
that.
of the FARC,
Just repeat that, because I didn't hear that real clear.
we're not opposed to assets that are properly available for attachment under TRIA being made available to victims. The issue here is the Kingpin Act assets are not covered by TRIA. And in the case of the FARC, there are no assets in the United States that would be available to victims.
The argument is if we don't have access, the argument is there is no good reason not to have them accessible under TRIA and under Kingpin. That's why we're here. We're here saying the system that's in place to compensate victims is not working. And we're here to try and fix that. We think people, American citizens, heroes, people who were imprisoned, tortured, murdered, trying to do the right thing for this country, to protect the citizens of this country, we think we shouldn't turn a deaf ear. And we think that it appears that we favor sometimes the people who perpetrated those crimes over the victims. And you say, well, they're not covered under Kingpin. Well, that's why we're here. We're trying to see that they are covered under Kingpin. They should be covered under Kingpin, and nobody is giving me one reason, compelling or even frivolous, why they shouldn't be yet.
What I'm trying to do is explain that the amendment that we're currently discussing, as applied, would go far beyond FARC assets. It would go into other drug trafficking organizations that have no relation to terrorism, no relation to the FARC, under our authorities. And those assets are a point of leverage that we have. They are one of many points of leverage that we have to try to dismantle those kinds of groups and prevent them from doing the kinds of things that the FARC has done to the victims in this case.
Well, you know, we don't have time, and I'm sure you can't tell me the type of assets we're talking about. But I just don't know how anybody could turn a blind eye to compensating the people that have suffered so much for trying to protect the people who work hard and play by the rules in this country, to turn a blind eye to that. And I would think that Department of Treasury and Department of Justice would be advocating for anything that would help compensate our victims, not standing in the way of anything that would help these people seek a legal remedy that the courts have already ordered to be justified.
Gentleman's time is expiring, and with that, I'd like to thank our panel of witnesses for their testimony today. I will note that you see a third microphone set up. State Department was invited 2 weeks ago. State Department decided not to show up, and I find that personally very unfortunate. And I'd like to extend, but again, I would like to extend my thanks to our panelists today. With that, we are going to recess until 5 minutes after this series of votes. The committee will come to order, and I would like to now extend to our second panel a warm welcome. And again, I was remiss in I think expressing this specifically when I pulled in that first panel, but having learned a little bit about this story, my condolences to the family and the victims and those that have had to live through this. I had a political science major, but a concentration in Latin American history and Latin American politics, and I've studied FARC, and I've studied a lot of those things, those conflicts that had happened from the Sandinistas on down, and we know how nasty those folks are, and so again, just to the families and the victims, you're in our thoughts and prayers. So with that, I'd like to extend a welcome to Mr. Thomas Howes, and sir, you will be given 5 minutes. And each of you on the panel, as we had talked about before, will be recognized for 5 minutes. You'll have to give your oral presentation. We will then, without objection, your written statements will be made part of the record after your oral remarks. And of course, the light that is in front of you on the table will start out green, go to yellow, and then hit red. When it is up, please suspend. So, and then after your presentations, each member up here will be given 5 minutes. And I understand we may have some other folks on their way as well for which to ask questions. So, with that, Mr. Howes, please lead off. You're recognized for 5 minutes.
Okay. Is this on? Okay. Good morning. My name is Tom Howes. I'm a U.S. citizen living in Congressman Posey's district. I was a co-pilot flying a state Department of Defense counter-narcotics surveillance mission in Colombia when we went down in FARC territory. The FARC executed our pilot, Tom Janis, a former Delta Force member. I was held hostage for 5.5 years, where I was tortured, chained, and starved. My fellow hostages, Keith Stansel and Mark Gonsalves, are here, also present. We were awarded the Secretary of Defense Medal for the defense of freedom for our services and sacrifice to the country. We sued the FARC under the Anti-Terrorism Act, and in 2010, the federal court in Tampa awarded us a judgment against the FARC and 80 individual FARC leaders. The FARC itself have no blocked assets in the U.S. Foreign terrorist organizations do not open bank accounts in their own name. Instead, they operate through drug trafficking, partner cartels, and their money launderers, the kingpins. In 1995, President Clinton declared a national emergency of cocaine traffickers centered in Colombia, blocking narco-trafficker assets in an executive order under Congress, the International Emergency Economic Powers Act, IEPA, which we talked about earlier today. TRIA authorizes terrorism victim judgment holders to execute on the blocked assets of agencies or instrumentalities of the terrorist party, even though the agency or instrumentality itself is not named in the judgment. TRIA allows us to execute on IEPA assets, but not assets blocked under the Kingpin Act. The Kingpin Act of 1999 was modeled on IEPA and expanded sanctions worldwide, not just on Colombian traffickers under IEPA. The FARC and its leaders are all designated under the Kingpin Act, not under IEPA. Since 2010, the administration has blocked all narco-trafficking assets under the Kingpin Act instead of IEPA. In 2013, the 11th Circuit Court ruled that assets blocked under the Kingpin Act were not included in TRIA's definition of blocked assets. So we lost the money, and it went back to the former FARC money launderer. We made several requests to Justice and Treasury for administrative relief, and all our requests were denied. The BASTA Act corrects this injustice by adding the Kingpin Act blocked assets to the list of blocked assets under TRIA. It makes no sense that TRIA allows terrorism victims to seize terrorist narco-trafficker assets blocked under one act of Congress, IEPA, but not assets blocked under another act of Congress, the Kingpin Act. BASTA will have no effect on the government's ability to designate, extradite, convict, and forfeit blocked assets of drug kingpins. In fact, allowing terrorism victims to go after narco-trafficker assets will only increase the administration's leverage because the blocked parties will want to be delisted as fast as possible. We have repeatedly asked Treasury to reclassify FARC assets to allow us to seize them, but we're either ignored or denied. There is no administrative solution, and legislative action is necessary. Thank you very much.
Gentleman yields back his time. And with that, we will, sorry, I just want to make sure I've got my list here of, we will go with Mr. Doug Farah. And, sir, you have 5 minutes as well.
Mr. Chairman, members of the subcommittee, thank you for this opportunity to testify about the FARC in Colombia, the world's premier hybrid terrorist.
Mr. Farah, can you suspend it? Can you just move that microphone a little closer to you as well?
Okay, is that better?
That is.
Okay, thank you. Thank you for the opportunity to talk about the FARC, which I think is the world's premier hybrid terrorist drug trafficking organization. I've had the privilege of being deeply involved in Colombia since 1989, and over the past quarter of a century, I've lived in Colombia a number of years and visit there regularly. The FARC, despite ongoing peace talks with the government of President Juan Manuel Santos, remains at the center of a multitude of criminal enterprises and terrorist activities that stretch from Colombia to Argentina and northward to Central America into direct ties with the Mexican drug cartels, primarily the Sinaloa organization. It is involved in the massive laundering of drug money, and recent cases by the Drug Enforcement Administration have shown the direct and growing criminal ties between the FARC, Hezbollah, and other terrorist organizations. The Treasury Department representative earlier this morning said that we try to tie all the drug trafficking back to the FARC. I would say if there's one grocery store in a neighborhood, everybody goes there to buy it, and the DEA tells us that at least 80% of the cocaine consumed in the United States is fabricated by the FARC. So yes, I think you can tie a great deal of the drug trafficking organizations directly to the FARC production. The FARC is one of only 3 organizations in the world that is designated by the U.S. government as both a major drug trafficking organization and an international terrorist entity. The European Union, Canada, and other countries share this assessment, and they've been designated in part initially as a terrorist organization because of the execution of U.S. citizens, something that's often forgotten. In 1993 and 1994, they kidnapped 6, in different incidents, 6 U.S. missionaries, killed them all while in captivity. In March 1999, the FARC abducted 3 Native American activists and killed them as well on the spot. And of course, we have the incident that brought us here today with these gentlemen who were serving their country and taken hostage by the FARC for 5.5 years. In 2001, shortly after the 9/11 attacks, the FARC was designated a specially designated global terrorist organization, which gave expanded power to the government to go after them. And in 2003, they're designated under the Kingpin Act. Under the protection of the governments of Venezuela, Ecuador, Nicaragua, Bolivia, and El Salvador, the FARC now maintains a robust international infrastructure that is producing and moving thousands of kilos of cocaine and laundering hundreds of millions of dollars. It has emerged as a pioneer hybrid criminal terrorist insurgency. The FARC is a central part of the revolutionary project of bringing together armed groups and terrorist organizations under the umbrella of the Bolivarian Revolution with the aid and support of Iran. The U.S. Treasury Department's Office of Foreign Assets Control, which has carried out at least 18 designations of FARC entities, describes the group as a narco-terrorist entity. There is now a significant body of evidence showing the FARC's operational alliance with Hezbollah and Hezbollah-based allies and other terrorist organizations in the region. A clear example of the breadth of the emerging alliances among criminal and terrorist organizations was Operation Titan, executed by Colombian and U.S. officials in 2008. They found that after a 2-year investigation that they were able to dismantle a drug trafficking organization that stretched from Colombia to Panama, Mexico, West Africa, the United States, and the Middle East. The cocaine used in that massive network was mostly derived from the FARC. Colombian and U.S. officials say that one of the key money launderers in the structure, Chucky Harb, a.k.a. Taliban, acted as a central go-between among Latin American drug trafficking organizations selling FARC-produced cocaine and Middle East radical groups. There has been little public acknowledgment of the Hezbollah ties to Latin American transnational criminal organizations, but recent indictments based on DEA cases point to the growing overlap of these groups. In December 2011, U.S. officials charged Ayman Juma, an accused Lebanese drug kingpin and Hezbollah financier, with smuggling tons of FARC-made cocaine to the United States and laundering hundreds of millions of dollars on behalf of the Zetas cartel in Mexico while operating in Panama, West Africa, and elsewhere. Juma was tied to a broader case of massive money laundering that led to the collapse of the Lebanese Canadian Bank, one of the primary financial institutions used by Hezbollah to finance its worldwide activities. Other cases include the July 6, 2009 indictment of Jamal Yusuf in the U.S. Southern District Court of New York, alleging the defendant, a former Syrian military officer arrested in Honduras, was seeking to sell weapons to the FARC, exchanging those weapons for cocaine, with the weapons coming initially from Hezbollah. The FARC is an unusual hybrid criminal terrorist organization that is among the largest cocaine producers in the world, deriving an increasing amount of its revenue from relationships with multiple terrorist and criminal organizations. The FARC maintains documented ties to Hezbollah, the ETA Basque separatist movement, armed remnants of the IRA, and various armed groups in Latin America. It has maintained ties to state sponsors of terrorism such as Iran and Muammar Gaddafi when he ruled Libya. It also maintains well-documented ties to the Sinaloa cartel, and in the computers, when they have killed other senior leaders of the FARC, they have found photos of Sinaloa cartel leaders sitting around drinking whiskey in parties with senior FARC leadership. There's no doubt that there is a direct link there. The ideological underpinnings of the FARC are Marxist and deeply anti-American, and the veneer of ideology that formed the basis of the relationship with Chavez and other terrorist organizations is now finally coming to light. I'll leave it there. Thank you very much.
Thank you. The gentleman's time has expired. You've got quite an extensive written testimony as well on that, and I appreciate that. And with that, we will go to Mr. Stephen Perlis for 5 minutes.
Good morning, Mr. Chairman. With your permission.
And please pull that nice and close.
Sure. Thank you. Is that better?
Yes, it is.
Thank you. With your permission, I will submit my written testimony for the record and, frankly, carry on from where Mr. Mulvaney left off. Before I do that, if I might very briefly introduce Mr. Chandler Derbyshire to you. Mr. Derbyshire is my summer intern. His uncle, Captain Vince Smith, was killed in the Beirut Marine Barracks bombing. His grandfather, General Keith Smith, was the organizer of what is now known as the Beirut Marine Barracks bombing litigation, in which we have used TRIA as a vehicle for restraining in excess of $1.8 billion of Iranian securities positions that were illicitly transiting New York. I'd also like to introduce my son, who is with me. I sent him out to Michigan to get an education. And he served on the staff of Senator Mark Kirk as a Senate Fellow in China Policy, using his Mandarin language fluency to hunt Iranian assets in China for Senator Kirk. Let me really start where Congressman Mulvaney left off and talk about how the process should work rather than what everybody else has been talking about today, and that is what's broken and not working. And let me put this in the context of first of the Beirut Marine Barracks bombing matter. Then Undersecretary Levy and I discussed the potential for seizing Iranian securities positions in New York that were outside his scope of authority to seize, but for which he had intelligence data. So effectively, we formed a private-public or a public-private partnership. And under that partnership, we sent the Treasury a subpoena. The Treasury obtained a protective order from the court system so that the intelligence data would be constrained in its public dissemination. And we used that intelligence data to seize Iranian assets in New York. As part of that discovery process, we have now obtained in excess of 100,000 pages of material about the movement of Iranian securities positions through the U.S. banking system. The government, in turn, issues us a subpoena, and we're actually under grand jury subpoena in the Southern District of New York, so we turn all of our discovery material over to the U.S. Attorney's Office. The net effect of this public-private partnership is that the victims get compensated and the government winds up with intelligence data that it didn't otherwise have. That's the way the system should work. In another case, there was a man from Michigan, Jack Armstrong, who was publicly beheaded on Al Jazeera television at the beginning of the Gulf War. We obtained a judgment for the Armstrong family against the government of Syria as the material supporter of al-Qaeda in Iraq at the time of the beheading. And again, we start this public-private partnership with the Treasury under TRIA, where we issue what I would call a friendly subpoena to the Treasury. They turn data over to us. We secured something in excess of $80 million of of Syrian blocked assets in the United States. We in turn, and that process is just winding up now, we in turn will take a portion of that money and reinvest it into asset location exercises. And when those exercises are complete, we'll voluntarily turn all of that data back over to the government. Again, you really want to have this public-private partnership where we get data, we start the process, that process brings in data, we turn it back to the government so that the victims' interests are advanced and the government's interests are advanced. I see very little merit in this notion that the government's interests are different than the interests of private citizenry. It doesn't have to be that way. That's a cultural gap that exists between the executive and the private bar. It certainly existed in 2000 when we really started this process for terror victims, and over the last 10 or 15 years, at least in the world of terror victims, a lot of those cultural barriers between the private bar and the government have really broken down, so that we're in very good shape in terms of going out and assisting each other.
Yeah, the gentleman's time has expired, and with that, I recognize myself for 5 minutes of questioning. So, Mr. Perlis, let's continue kind of down that, I guess. So just to make sure I'm understanding, this PPP that you're kind of talking about, this hybrid public-private partnership that has worked previously, is not happening now, correct?
Not in the case
in
of,
this particular
of the FARC
case.
and FARC assets.
Why do you believe that is not? And is that something viable that should be pursued?
Well, you know, I don't make public policy here. I'm really a technician. But if you're asking me as a policy matter, would I like to see it pursued? Yes. I think in the
is there, okay, so let me sharpen it. Is there any reason why we couldn't or shouldn't be doing that in this case?
No, actually, I'd encourage you to do it.
Okay. Or encourage Treasury to do that.
Encourage Treasury to do it. I mean,
do you need to have a willing Treasury to be able to do that?
You need either a willing Treasury or a willing Congress.
Okay.
In the first instance, I would hope the Treasury would do it voluntarily. From what I heard today, the mindset of Treasury is very much like the mindset we saw at the State Department in 1998, 1999, 2000, and that is they want the blocked assets for other purposes.
Other projects.
Right. Other projects. I think in 98 it was really more the legacy of Jimmy Carter's negotiation of the Algiers Accord, facilitating the release of the Tehran hostages. State wanted that money in order to be able to bribe out the release of American diplomats. I happened to be on the Senate staff at the time that agreement was negotiated. I didn't care for it then, and I don't care for it now. I don't think it's an appropriate way for the U.S. to conduct itself.
In your opinion, is BASTA a bill that is careful to avoid unintended consequences?
Yeah, I think it is. I was actually quite flattered when Congressman Posey's office called me and asked me if I would give some pro bono time to reviewing the bill. I have not gone through the current draft. I've gone through several of the early iterations of the bill. I think it's very narrowly focused. I would encourage the committee to seek other people's views. You have to be very careful here not to do anything unintended. As far as I know, the bill does not do anything unintended. I would still seek other people's views.
Okay. Mr. Howes, and again, thank you for being here. I'm sure I could tell, just as you're starting to talk about it, this must be very difficult to relive and to talk about. But it's an important story, so thank you for sharing that. But would you please describe your efforts to receive compensation for your treatment by FARC and kind of what you've gone through so far?
Well, we've done a number of things. We started out in 2010, 2011. We made 3 separate requests for crime victim relief with the Justice Department, and everything was denied. In 2013, we made another 3 separate requests to the Treasury Department to get licensed to execute on blocked kingpin assets of 7 FARC, or the agencies or instrumentalities. One of them was a FARC commander. Everything, again, denied. And we asked the Treasury to redesignate the kingpin, these kingpins under AIPA. Again, no, denied. And the OFAC response was, I have here, it says, OFAC does not respond to requests to designate individuals or entities pursuant to certain authorities. Basically, ignored or denied, I guess you'd say. And we've also provided all copies of this information of the administration's denials here for the record.
Do you believe that there's sufficient evidence that FARC or those commanders and those designated people have assets to be able to go and seize? Or are we going to have to go at them through other drug kingpins who may have assets here as well?
Well, I think the FARC themselves, it's fairly difficult. As I mentioned earlier, they don't put bank accounts and that sort of thing together. It's mostly the agencies and instrumentalities that handle the money for the FARC.
But certain individuals could.
Certainly.
Okay.
Yeah.
And do you know of any that have or do have those kinds of assets?
As far as the
those
agents, instrumentalities for the FARC?
Yeah, those individuals, those commanders, or
well, these were 7 that we looked at here, and we were denied on all of them, under the Kingpin Act. So yes.
Okay. With that, my time has expired. With that, the chair recognizes Mr. Posey for 5 minutes of questioning.
Thank you very much, Mr. Chairman. The testimony written today is compelling. It's lengthy, it's highly detailed, technically perfect as far as I can see, and really gives a lot of insight into a system that is just not working right and not working as it was intended. In fairness, I think DOJ should be commended for their ability to track the assets. That's not simple. That's good intel work, hard work, and their persistence in trying to bring many of these criminals to justice. It's taken many, many years. It took, I guess, maybe 11 years to get one of the guys that was responsible for Mr. Howes. And it just took a lot of persistence, and I want to commend DOJ for that. But, it's troubling that it appears to me that the executive branch would enter a lawsuit into which they were not originally a party. Is that correct, Mr. Howes? Did you have a lawsuit and in the 11th Circuit Court of Appeals? Did the agency inject itself into the lawsuit at that point, or had they already been a party to it?
I believe they, am I on? Okay. I believe they, injected into it? Yes. Yes.
Yeah, I mean, here we have, we have a law-abiding American citizen, a victim of narcotics trafficking terrorist, and somebody who'd been imprisoned by him, tortured by him, seen a colleague murdered by him, and he's trying to get justice against the criminals. And if I read this correctly, the executive branch jumped in and challenged the definition of a blocked asset, which really kind of was the first big rock thrown into the cogs here to stop the process from functioning probably as it intended. Am I reading this correctly?
Yes. It's a stretch for anyone to wonder why an agency would do that. Why they would do that. Their logic that, well, if we control all their blocked assets, it harms them more than people who they have harmed getting some of those assets. I see with blocked access, if I'm a bad guy and you block my assets, at some point, someday, I may be able to recover them. Maybe a technicality in a court of law or whatever, transform them somehow. But if people I've harmed are allowed, through the courts, absolutely proper legal jurisdiction, to get those assets, I think that probably hurts the narcotics trafficker and terrorist more than just having his assets blocked. Does that seem like a logical conclusion? Anybody in the witness disagree with that? Well, it certainly should, and it seems opposite of having these assets returned to actual drug launderers and drug traffickers.
Yeah, and so the next question is, what happens, what are the different things that happen to blocked access? Anybody know? Did they just stay blocked forever until they maybe arrest and convict a guy? And then what happens to the assets if they convict him? Maybe.
Well, in one case, and I think we've got the record on file, that it's a percentage of it's returned to the drug trafficker, money launderer, returned to him.
Does the agency keep any of the money? Anybody know? Ms. Peerless?
Well, I can't answer that question with respect to FARC assets because I don't practice in that area. I think a good example, though, is the case of Libya. Libya saw a whole series of lawsuits marching in its direction, whether it's Lockerbie, which was not one of my cases, or Libya's bombing of the Labelle discotheque, which was one of my cases. And the total reparations paid by Libya to U.S. citizens, I suspect, was in excess of $3 billion. Those reparations were paid because Libya understood at the end of the day its blocked assets in the United States were going to be used to satisfy impending judgments. When the United States and Libya reached an agreement and those reparations were paid, the United States then released Libya's governmental blocked assets as part of the normalization agreement between the United States and Libya.
Was the entire $3 billion awarded to victims?
The $3 billion represented prejudgment settlements between Libya and the U.S. victims, and parties were paid. That is correct.
Okay.
Sorry, the gentleman's time has expired, but without objection from the panelists, if we wanted to do a second round of
Thank you.
times and questionings, I know I have some questions as well. So if that's all right with our panelists who've got the time, and we're all good on this side as well. So, granting myself 5 minutes here, Mr. Farah, your testimony says that FARC is, quote, under the protection of the governments of Venezuela, Ecuador, Nicaragua, and Bolivia. And certainly all of them have had their own issues over the years. And how well documented is that, quote unquote, protection? Is it well enough to describe those governments as instrumentalities of FARC with assets to go after there or to block?
Thank you. I think that's a really interesting question. The documentation on Venezuela is overwhelming, and we have, including OFAC, designations of very senior Venezuelan officials for both their relationship with the FARC and drug trafficking. At least 6 of Chavez, when he was alive, Chavez's closest advisors were designated, and they continue to be very powerful in the current administration of Nicolás Maduro. Bolivia, I think, again, the evidence is overwhelming. I think you have to understand that to the Bolivarian system set up by Chavez, which is his goal of creating this united Bolivarian set of nations, the FARC was viewed as a primary instrument for achieving that. And he supported very openly the FARC as an armed movement and called for other armed groups to join in armed insurrection against the democratic countries in the region, and chose to use his oil money to finance the election of Rafael Correa, Evo Morales, and then Daniel Ortega. So I think that if you understand that the FARC is, in their view, an instrument of foreign policy, which their support for the groups, I think, is overwhelming, especially if you look at the documentation that comes from captured FARC documents in the Raul Reyes computer and the Monojojoy computers, where you have the internal communication of the FARC discussing in great detail the relationships with Bolivia, with Correa, with Chavez, where they specifically asked President Correa, for example, in Ecuador, to move certain commanders from the border area because they were being too aggressive against the FARC, and they write back and say, "Sure, we'll move. Who would you like to see placed there?" That's a pretty direct relationship.
But that would need to be proven in court, I would assume.
The court the documents showing that exist and actually in that particular case are a matter of public record, have been published.
Okay, Mr. Perlis, what do you think of this sort of line? And because obviously FARC is not a state or a country per se, which is what your previous lawsuits had been trying to do, correct? Tie that in with that sponsorship. And wouldn't permanently attaching funds of FARC instrumentalities be noticeably different than for state sponsors somehow? What's your thoughts on this?
I don't see any interference between the kind of litigation that I bring against state sponsors and expanding TRIA.
Can you move your mic a little closer again,
sure.
please? Thanks.
Yeah, I'm sorry. Let me start again. If you're asking me, if I understood the question properly, do I see any potential conflict between the kind of litigation that I brought against state sponsors of terrorism and expanding TRIA to include the FARC? And the answer is I don't see any conflict at all. You know, the whole notion of TRIA and really goes back to an Iranian weapons account that we tried to seize on behalf of the family of Elisa Flato, who was killed in a bus bombing in Israel, Matt Eisenfeld, who was killed in a bus bombing in Israel, Sarah Duker, who was killed in a bus bombing in Israel, and Father Lawrence Martinjenko, who was taken hostage in Beirut, Lebanon. And this litigation really occurred in the late 1990s, and we heard many of the same objections from the State Department that I listened to this morning. Congress passed legislation called the Victims Act 2000, which freed up this weapons account for these families, and then went on 2 years later and fixed the problem generically in TRIA. The U.S. government has historically taken the position that when an asset is blocked, the mantle of U.S. governmental immunity protects that asset, so that even if a terrorist state were had lost its immunity under the Foreign Sovereign Immunities Act, we still couldn't pierce through to that asset. Because of U.S. governmental immunity, TRIA really fixes that immunity question. I look at TRIA as a congressional waiver of the government's immunity when it holds blocked assets. Same thing would be true for FARC assets. And if you look at it from that perspective, there's just no potential interference or collision between the enforcement of a judgment against a terrorist state, against a blocked terrorist state asset, or a judgment against the FARC under ATA against a blocked FARC asset.
Great, thank you. I appreciate that perspective. And with that, I will grant 5 minutes to Mr. Posey for questions.
Thank you, Mr. Chairman. I'm still trying to get my arms around why the government would block recovery by an American citizen who's been harmed by a foreign terrorist group. It's still it's still hard to grasp that we would do that, and tend to want to look at consent decrees again. You know, how much of the seized assets at the end of the day ever go to the victims, and how much is gobbled up by the federal agencies. I've asked DOJ for a list of consent decrees before, and they were not forthcoming, so they didn't have time to tell me the details. So it'll be a while, but eventually we'll get them. And I question for Mr. House, what did you do to petition the Treasury to change their designation of FARC assets and FARC agent instrumentality assets from Kingpin to EPA so that you can seize assets under TRIA?
Well, we made the request to redesignate the Kingpin accounts, but we were turned down. Does that answer your question? Yeah.
All right. When you go after FARC assets, do you claim that every blocked narco-trafficking asset blocked under Kingpin is subject to seizure, or are you careful about who you go after?
Yeah, we're certainly careful who's gone after. We go after, only blocked assets of the foreign Kingpin narco-traffickers, which the federal court determines are agencies or instrumentalities of the FARC. We don't go after, for example, kingpins who do not traffic in FARC cocaine. We don't go after narcotics traffickers that traffic drugs for the Taliban, for example. So it's specific to instrumentalities and agencies of the FARC.
You know, I read your testimony, and it really could be a great mystery novel, a whodunit, because it's really difficult for anyone who reads it to understand why the federal government would block you. I mean, it's a mystery. I can't imagine the thought that, again, the federal government would have more ability to work against the traffickers if they don't let you recover their assets for the crimes they've committed. Did they ever give you any logical explanation for that?
No, and again, the court, there was a judgment in our favor by the court, and yet I feel like we're blocked by the Department of Justice and the Treasury. So it's a mystery to us.
Mr. Chairman, I'm just bedazzled over this whole thing, and I have a lot of questions that I'd like to ask the Treasury and DOJ again. If maybe we could think about bringing them back in here. Sometimes when we have the government witnesses first, we hear some things that really make a lot less sense after we hear the second private sector witnesses. And this is another one of those cases. the testimony and discussion with these gentlemen have generated a significant number of questions that I would like to address with Treasury and DOJ again. And I'd say normally I would just write them a letter and ask for a response, but I've been relatively unsuccessful in getting information in that manner before, and in some instances take 9 months to answer a relatively simple question that I've asked from federal agencies. So after, I'd like to have a discussion with you maybe about extending this hearing for another round. But I yield back, and thank you, Mr. Chairman.
Gentleman yields back, and we, of course, do have an opportunity for you to do some things here on the official side, but I'd like to thank our witnesses for being here today. Very illuminating, I think frustrating for a number of us to hear your testimony and some of the answers that we have had or non-answers that we have had about what has been going on from our own government. And again, Mr. Howes and to the other gentlemen, we appreciate your perseverance and your willingness to come and join us today and share this amazing story. And we just blessings and pray for the best for you as you move forward. But without objection, all members will have 5 legislative days within which to submit additional written questions to the chair, which I will then forward to the witnesses. My suspicion is there might be a couple of questions that Mr. Posey has that we'll be forwarding on, and I ask our witnesses to respond promptly as they're able to. And without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record as well, and without objection.
Mr. Chairman, can I add one more comment?
Without objection.
Okay. You know, today we're talking about an injustice that's been done to one of my constituents and 2 of his colleagues. If you see what's happening in the narcotics trafficking world, I had an occasion to go visit the border at Nogales earlier this year and was overwhelmed by the conditions that are there. The narcotics trafficking, the human trafficking, the arms trafficking that's going unabated. And the reality is it's becoming more and more prevalent in this country. It's permeating us more and more and more every day. And while we just see 5.5 years of imprisonment and torture for my constituent in South America today, tomorrow it could be your constituent or any member's constituent in this country. If you see or saw what I've seen about how the narcotics traffickers, the cartels, deal with people who get in their way or don't cooperate with them, it's chilling, it's frightening, and it's a threat to every man, woman, and child in the United States of America. This, while it may be justice that we're talking about for 3 gentlemen today, could affect any man, woman, and child in the United States of America in coming years. And I again want to thank you, applaud you, and Chairman Hensling for addressing this issue, to doing whatever we can to dam up or try and stop the flow of terror that goes with narcotics coming into this country, and salute again the gentleman that tried to do something about it. Thank you. Thank you, Mr. Chairman.
Well, thank you, and I appreciate your bringing this to everyone's attention and to light. So without objection, this hearing is adjourned.